D.D. Sewell replied October 31st. I believe you got everything we have. AG had requested our files, so we asked them to provide discovery to you. Ms. Clark replied on October 31st to DDA Sewell, which was forwarded to Mr. Thompson. Yes, what the AG passed along is the complete copy. See, it's the complete copy. Before I leave the topic of the district attorney's office documents on Mr. McCool's discovery topic area, that DDA Sewell practice was always been to invite defense counsels to meet and review PCR discovery material, and that this provided counsel with the opportunity to better understand what the DA office was providing in discovery, as well as what the DA office considered protected, whether by work product, confidentiality, criminal history printout, or privilege and protected by nature. Sewell told me he believed this opportunity to review the district attorney file material was communicated to Mr. Thompson. Clearly, the email communication left unresolved whether Thompson wished to see additional DA file material. In this case, it's unfortunate the two attorneys did not meet for such a review. In any event, I extend that offer again to Mr. Thompson. Mr. Thompson may contact me and review the DA's attorney file material. He can see the DA jacket, accordion files, including where the DA copied the Delberg report was found, because the location suggested why it wasn't found. I was describing in detail that location. And so that's kind of it right there. So yeah, we're just gonna hit you with the conclusion. The conclusion is, this is what they conclude. Let's see. The 7/22/00 Delbert report, which Mr. Olcott Thompson identified as Exhibit 4, was missed by the DA's office staff when preparing discovery copies of police reports and other file materials for the Department of Justice. The district attorney's office should have found this report and those other included in attachment B. This office should have been provided these reports and the documents as part of, this office should have been provided these reports and documents as part of October 9, 2014 disclosure. Nevertheless, I believe this matter of missing reports could have been better been addressed by Mr. Thompson, asking DDA Sewell if missing reports could have been, if Mr. Thompson had met Sewell to review DA file matters, if he thought something was missing, or specifically, if Mr. Thompson identified the reports to Mr. Sewell to ask if it could have been overlooked. That said, as I looked at the transcript of the trial testimony, the district attorney's office file materials, and have spoken to former DDA Jones, I believe this report is contained in attachment A, was as well those attachment B were provided to Mr. Brennan for trial discovery. So he's vouching for her. He's saying what he believed. He talked to her and what he believed. So see, all the people that he's a witness, and the staff members as witnesses. DDA Sewell is a witness, because he's blaming Sewell and his staff for the discovery violation. And I wonder if they agree. Do they agree with that? Is it their fault? Is it the staff members' fault? You know, he's the main person that's saying, "Hey, it's their fault," and I talked to. He's the main person. See, he needs to testify. Like, what was that discussion Miss Jones had with you now? Because he's a witness. See, he's part of the cover up. Because he said, "Yeah, I vouched for Miss Jones. I talked to her and I believe her. And she said he did it. It was their fault that discovery lies." See, he's the cover up guy. He know all of it. I reviewed everything and everything is good. I talked to Sewell, his staff, and I talked to Jones and he said, "Hey, I know everything." He need to testify though. You see what I mean? What's his name? Aaron James, I think. No, this is Russell Ratto. Yeah, Russell need to testify. See what I mean? Because how did she tell you about the police report? When did she disclose the police report? Um, because I don't know if you know, but did she tell the judge? Okay, she told the judge she wasn't going that she wasn't going to disclose or she wasn't going to use threat evidence during trial. Therefore, it wasn't no police. So we know we didn't get no police report from the court order from the judge. So when did she disclose police reports to Mr. Brennan? She never did. See, and how we know she never did is because it wasn't in the chunk of discovery. See, this when they disclosed this information to me, that was 16 years after the trial. See, I mean that's everything. You know what I mean? That's everything we got. And the police report wasn't in there, but my lawyer had the police report that should have been there in his hand. See, it was caught, and so now they covering up. And he's talking about how he didn't talk to DAs and different things. So now they need to testify about it because what the DA did is wrong. You know, she didn't disclose that document. Okay, but whatever. The whole point is the date on that document and that incident that date happened had no influence on the exoneration statement. So she misused people. She coerced Savande to lie and know when to lie. How did Savande know when the question was coming to lie to it? They had to conspire. She prepped her. She coached her. You see what I'm saying? And you shouldn't have to do that to win. You got all the awesome power at your disposal. And so now the altercation happened on July 22nd, 2000. Trial started around the altercation happened on July 22nd, 2000. Trial started around September 25, 2000. Miss Jones was sitting on the information for about 2 months. She could have, because she said she had the police report. Okay, so now when we asked for it at the omnibus hearing, she should have gave it to us because she had it. She had it in her possession. This altercation happened on the 22nd of 2000. Trial started around September 25, 2000. Miss Jones was sitting on that information for about 2 months. She could have disclosed the information to the defense at the omnibus hearing on September 20th, 2000. See, here it is. She admitted she had the police reports. So why didn't she disclose it to us at the omnibus hearing on the 20th? See, she had them. And she was holding on to that shit because she knew if she discloses it, she loses her redemption of Savande's identification. See, and without redeeming Savande's identification, they can't get a conviction. And so she was willing to put it all on the line for that. And so if she had the police report, she should have disclosed it to us at the omnibus hearing. But you heard her tell the judge, no, Your Honor, I'm not going to offer that at trial. And the judge saying, if she do, I should get the information. And so, Brennan should have did some things, but I mean, it's neither here or there now. But he was just ineffective. He was an ineffective attorney, man. That's just the truth. He could have did a number of things that I got listed, but we ain't even gonna harp on that. He just was an ineffective assistant dude. And so, let's see what I said here. It says a reasonable competent attorney would have used the date on the withheld police report to demonstrate Ms. Holmes committed perjury, and Ms. Jones knew she was committing perjury when she testified she was threatened, and the threat made her tell them she didn't know or see nothing. See, and it's real. This is the key. Ms. Holmes knew the altercation where Mr. Spencer supposedly threatened her happened after the meeting with Jones and Lapsy. She knew it. Because it was her experience. She knew for a fact. Yet, she gave testimony that made it seem like the threat happened before the meeting on July 19, 2000. The date on the police report proves Ms. Holmes was lying. When she testified, she received a threat before the meetings, and the threat was the reason she told Jones and Lapp she didn't know or see nothing. Ms. Jones knew Ms. Holmes was committing perjury, providing false and misleading testimony because she possessed the police report, knew the date on the police report, and she had first-hand knowledge of the date on the police report. Based on the date on the police report, she knew the altercation between Holmes and Spencer did not happen before July 19, 2000. Based on the date on the police report, 7/22/00, based on the data on the police report, she knew the altercation at the liquor store where Spencer allegedly threatened Ms. Holmes happened 3 days after the meeting and knew it had no influence on the statements made on July 19, 2000. Knowing that, Ms. Jones still asked Ms. Holmes questions that caused her to give misleading answers to the jury that made it seem like she was threatened before the meetings on July 19, 2000. Ms. Jones knew Ms. Holmes was committing perjury, providing false and misleading testimony to redeem her identification. And Mr. Brennan was just ineffective. He didn't do nothing about it. He just left it. But I mean, and see, that's why the state, when I went back to trial, when I won my appeal and went back and put that before the court, they dismissed my trial because I said I want to have a hearing. All this got to be excluded. I want my day in court, and they'd rather dismiss the charge than me having my day in court, and that's what happened. You see what I mean? They waved the flag. They say we give up, dismissed all my charges, and exonerated me. And when I went to prison, I didn't have no. That was my first offense. They gave me 25 years on my first offense. So when I won my appeal, I got all my rights back. My right to vote, my Second Amendment rights, I got all my rights back. So I got my gun permit, and it's just, thank God for the slaves, man. Thank God and they sacrificed for us. So, so due process, we would reap the benefits of due process, man. And yes, it's been a long ride and long struggle, and we get it. We know the American history. But this is where we at now, and the sacrifice of the slave is working to where due process is afforded to a person like me. When I get all my rights back, I have my record expunged. I got my gun permit. Yeah, I stay with it, but this is legit. This is I got a license to carry a firearms. You know what I'm saying? And that's a responsibility right there. That's not nothing to play with. You know what I mean? So I just respect it. I appreciate the slaves. I appreciate Harriet Tubman. I appreciate the former slaves for fighting in the Civil War because that's how we got our right to bear arms. They gave muskets and they gave bayonets and whatnot to the former slaves, the free men. You see what I'm saying? They gave them guns, and when they gave them guns, guess what? They gave us guns. See, that's what the sacrifice was about, and so that's when we truly got our Second Amendment rights. It's after the war. And shit, after the war, man, them brothers went back home, man, with them guns. Like, yeah, man, we just killed Whitey, man. They was on. But I mean, we had our day in the sun for a couple of years in Reconstruction. It was a beautiful sight where black people they start, feeling themselves. You know what I mean? We become a congressman, we become the senators, we part of the politics. We pulling ourselves up from our own bootstraps. We buying property, we tilling our own land. Yeah. Next thing you know, the Ku Klux Klan and a bunch of terrorists. And it's deep, but thank God that they sacrificed because it's working today. Where I can go in the sheriff's office and get a gun permit. Black man. You see what I'm saying? Um, I can get a business license and own a business. Can go in the bank and do business at any bank. We take these things for granted because it was a time, man, black people had no access. So, shout out to the former slaves, man, and just they sacrificed the ancestors, man. People talk that shit about the ancestors, man. We not our ancestors. No, no, you're not our ancestors because the ancestors had foresight. Yeah, they took them beatings and stuff so we can benefit today. They had the foresight, and that's our problem. We don't have foresight these days, man. No, we just reactionary people, emotionary people reacting off some shit we see on the internet or some shit. Man, we got to get back to that spirit of the '60s, but mix it with this technology. You know what I mean? And like really be about that generational wealth, man. Be about your family. Be about building. And so yeah, I'm gonna tap in on at some point I plan to go do a show from the range, and just touch more about it though, as far as the history of Harriet Tubman and conceal what I mean, our Second Amendment right. The first impulse shouldn't be when you see a black person with a gun that he doing something wrong. No, I have a Second Amendment right in this country to bear arms. Yes, and I exercise my right. And I can still vote for Kamala Harris and be a gun owner. You know what I mean? Or whoever you vote for, Trump, whatever. Should hopefully Trump make it to where, sooner than later, where people can, with gun permits and shit, can fly all over the place and go anywhere with their gun permit instead of, the certain spots like Oregon, about 22, 23 countries that honor our concealed weapons permits. So, yeah, I'll be glad when the shit is all over the whole country because, I mean, shit, man, it is what it is. But yeah, let's just walk you guys down through, all that happened you know, um, with this discovery. We even got a charity situation. We're gonna talk about charity, but I think we didn't beat this drum on Savanda enough, and I mean, you guys see what it is, and this ain't we reading it straight out the paperwork, the facts about what happened, and that's what happened. They try to cover up for this lady, man, and ultimately, she knew it was wrong, and that's why she tried to cover up. That's why she withheld the documents and then tried to cover up. But the cover up is worse, and so they got to be held responsible. And see, that's what this lawsuit is all about: responsibility. See, nobody's bigger than the program, and nobody's bigger than the law, man. In order for us to have a country, the law got to be upheld. You know, nobody should be above the law. That's the truth. You know, and so again, we need better gatekeepers to hold that line and to also protect our 12, 13, 14% interest in this whole fight. You know, it's deep, y'all. And again, man, those people that's in Louisiana, man, become congressmen and senators and help them brothers get out of jail. You know, man, make sure that the people that you vote for is going to try to help them people get out of jail. Again, man, I don't even want to go to the Essence Fest until them brothers get out of jail. So I'm halfway boycott. I ain't putting it out there like that, but I mean, shit, man. Man, let them people out the penitentiary, man, like CJ Max said. Man, let them out. You know what I mean? They sitting up in there in prison unconstitutional. And it's wrong that just because I'm in a blue state and they follow the sitting judge, which is a blue judge, that we was afforded benefits that they're not afforded in Louisiana just because they live in a red state. That's wrong, man. And it shouldn't even be along them political lines, man. It don't matter if you red or blue. What's right is right. Republicans especially talk all that shit about the Constitution, but don't want to uphold the Constitution when it's time for them to uphold the Constitution. And if that means that some people get a fair day in court because of it in that fashion, so be it. It's nobody's bigger than the program. And in order for us to have a country, that's the rule of law got to be upheld. Nobody should be able to cheat. And if they found cheating, then the case is dismissed. The case is thrown out. It's contaminated. It's tainted. It's no longer good. And that's just the fact of the matter. And so yeah. So we gonna the next one we're gonna kind of get into Charity Amos, and we're gonna do that on a different day. I think we covered everything with Savande though. Yeah, but you guys see it. The DA basically banned. You know what I mean? She withheld documents. You know, and then she turned around and coerced this lady to lie. She misleaded the jury with false perjured testimony. You know, an event that goes against the laws of nature, and then they covered it up, and start blaming people for the discovery violation. Because they got caught, and it's all bad, man. And they shouldn't have to use that all that, and now they covering up shit. So you guys be the judge, man. Like, subscribe, comment, do all that. But man, it's just, man, spread the word, man, because we need to hold these people accountable. You know what I mean? You know, we just in the beginning phases, and so we need that support too, that pressure on them. Just awareness. Justice. That's what it's all about. Because nobody's bigger than the program, and if we want to have a country, it's got to be accountability. You know what I mean? So, yeah, man, shit. That's how we gonna start it. And again, we're gonna touch bases with Charity shit next, man, because her shit is just as bad in a different way. Where yeah, we'll tap in with it. Yeah, this is how we gonna wrap it up as far as with Savannah. The preliminary question of facts. See, it all comes down to the basics. Preliminary question of facts. See, this is the reason why I never should have been in front of the jury in the first place. Uh, I said Miss Holmes' identification must be excluded. Miss Holmes' identification must be excluded based on the preliminary question of fact. And here goes the preliminary question of fact. Was Miss Holmes, in fact, threatened by DeMarcus Spencer before July 19th, 2000? That's the preliminary question of fact. See, that got to be answered before any evidence can move forward, supposedly. See what I mean? That's how it works. But see, this is again, my attorney was just a dump truck. He didn't protect me. But did the alleged threat influence the statements made to former DA Nicola Jones and defense investigator Randy Lapp on July 19, 2000? On July 19, 2000, Ms. Holmes met with former DA Jones and Randy Lapp. During the meeting with Jones, Ms. Holmes stated she didn't know nothing, she ain't saying nothing, she just made everything up. She said somebody else told her and she was saying what somebody else told her. During the meeting with Randy Lapp, Ms. Holmes stated she didn't know nothing and she didn't say nothing. Ms. Holmes made exonerating statements to Jones and Lapp despite previously identifying Mr. McCool as the person that shot Harry Villa and herself. The statements to Jones and Lapp created inconsistent statements that would have cleared Mr. McCool. Ms. Holmes testified she lied to Jones and Lapp during the meeting on July 19th because she had been threatened by DeMarcus Spencer. And it got the page sites. Thereafter, the threat evidence was used to redeem Ms. Holmes' identification and credibility. In regards to the threat evidence, the tail is wagging the dog. And so it's got the timeline that I showed you guys, the timeline. Where is it at? Somewhere around here. All right, here's the timeline. In regards to the threat evidence, the tail is wagging the dog. Exhibit 1, the timeline. On July 22nd, Ms. Holmes and Mr. Spencer allegedly had an altercation at the liquor store. This altercation was used as the justification for the statements made to Jones and Lapp during the meeting on July 19, 2000. And so you got the police report exhibit, which has the 22nd on it, and then transcript pages. Ms. Holmes' explanation for the inconsistent statements were consistent with the information articulated in the police report. See, the testimony and that is the same story, it's linked. Now, based on the 7/22/00 date on the police report, on or before the 19th of July, the above threat or altercation hadn't taken place yet. It is no way possible that incident on July 22nd, 2000 influenced the statements made on July 19th, 2000. It is incredible as a matter of law and goes against the law of nature. As a preliminary question of fact, the described threat or altercation hadn't occurred on or before July 19, 2000. So it's no way possible that incident on July 22nd influenced statements made to Jones and Lapp on July 19th. The threat evidence is insufficient to redeem Ms. Holmes' identification and credibility. The threat evidence and identification must be suppressed and excluded based on the fact it's insufficient to go before a jury. See? And they just talk about it on September 22nd during an omnibus hearing. You know, and it goes on and talk about the discovery violation. You know, well, we just basically talked about all the stuff about the DA knowing, offering perjury. You know, explained he spoke with former Jones, and he believed the report was provided to the defense counsel because Jones confirmed that she would have provided this 7/22 report to Brennan as trial developed. Now, based on the email, Jones admitted being in possession of the police report. The statement in email proves Jones possessed the police report during the omnibus hearing. See, she's saying she had it, she possessed it during the omnibus hearing. It also proves Jones should have disclosed the police report to the defense at that time during the omnibus hearing. Furthermore, it proves former DA Jones knew the date on the police report was 7/22/00. See, she knew the date on it. And so DA Ratto blames everyone in the DA's office for the discovery violation to minimize the harm. However, the fact that Jones possessed the police report and knew the date on the police report demonstrates Jones knew Ms. Holmes was going to provide false, perjured, and misleading testimony to the jury to redeem her identification and credibility. Based on the date on the 7/22/00 police report, Ms. Jones knew for a fact the alleged incident between Holmes and Spencer took place on July 22nd, 2000, 3 days after Holmes met with Jones and Lapp on the July 19th, 2000. Based on the date on the 7/22/00 police report, Ms. Jones knew for a fact on July 19th, 2000, the incident on July 22nd, 2000 between Holmes and Spencer hadn't occurred yet. See, she knew because she had the police report. Based on the date on the police report, Ms. Jones knew for a fact there's no way possible the incident on the 22nd had any influence on Ms. Holmes' statements on the 19th. You know, I mean, she knew. During the offer of proof, Ms. Jones attempted to bring in hearsay statements, state of mind evidence to explain what Ms. Holmes was thinking when she made inconsistent statements on the 19th of 2000, as if Ms. Holmes was thinking about statements from Spencer when she met with Jones and Lapp on the 19th of July. You know, like we said, the court denied it, but the court denied Jones' attempt to bring in the hearsay evidence. However, the attempt demonstrates Jones' intent to bring in false, perjured, and misleading testimony that would have further misled the jury into believing the incident on July 22nd, 2000 influenced the statements on Ms. Holmes made on July 19, 2000. Based on Ms. Jones' possession of the police report and the date on the police report, Jones knew for a fact the testimony would have been false, perjured, and misleading. She knew for a fact the incident with Holmes and Spencer occurred on the 22nd. She knew on the 19th the incident hadn't taken place yet between the two. Before the offer of proof and after offer of proof, Ms. Jones asked Ms. Holmes questions that caused Ms. Holmes to give misleading answers before the jury that made it seem like the incident with Spencer influenced Ms. Holmes' statements on the 19th of July, when Ms. Jones knew for a fact the incident with Spencer occurred on the 22nd, 3 days after the 19th of July. Ms. Jones and Ms. Holmes knowingly provided false, perjured, and misleading testimony when they used the incident with Mr. Spencer to redeem Holmes' identification and credibility, evidence designed to confuse and mislead the jury. Ms. Jones defied a court order and was dishonest with Judge Keys when she told him she was not going to offer threat evidence during trial. It's reasonable to conclude she was untruthful because she did not want to risk getting the threat evidence suppressed because of the date on the police report, 7/22/00. Without the threat evidence, Ms. Holmes' credibility and identification could not have been redeemed. And without Ms. Holmes' identification, there would not have been enough evidence to convict. The DA can strike hard blows, but not foul ones. And that's from Mooney versus Houlihan, I believe. The DA can strike hard blows, but not foul ones. You know, so yeah, there you have it. I think we covered everything though. As far as Sabunda, and we just, kind of just wrapped it up, just letting you know. The preliminary question of fact is just, it's clear as day. It's no way possible that, there's no way possible that incident on July 22nd influenced the statements on the 19th. And everything they did to cover that up is the reason why they gotta be held accountable in this lawsuit. And that's the truth, because nobody's bigger than the program, nobody's above the law, and the DA's office gotta be held accountable. You cannot cheat. You got all the awesome power of the state, all the awesome power of the government. Do not cheat. And that's it. And that's why we need more black attorneys, not sellouts though. Black people that's gonna really hold the line for other blacks. I mean, not doing anything against the law or nothing like that, but just make sure if you're a police officer, you're a black police officer, make sure this black man make it home. You see what I'm saying? Don't be letting your friends and the police officers beat on him and stuff. If you see it, report it. You see what I mean? You got bills to pay. You got car payments, mortgages. I get it, but nobody's bigger than the program, and that's what we got to get back to. Don't do nothing against the Constitution, man. Hold your oath and all that, but just make sure that you know, if you see some white cop beating on some black dude, it ain't right. Whatever the case, man, handle your business, man. Stand up and go, speak for that man. We need more lawyers, we need more doctors, we need more congressmen, we need more senators, people at the seat of power um where decisions is being made. We gotta get creative, start creating our own stuff and creating our own businesses and controlling our own destiny. And so we just gotta get off this petty shit. We gotta get off this anti shit. And we got to get on some, like, man, this is the American fabric shit. Our ancestors sacrificed so we can benefit. So let's benefit. Let's get bank loans. Man, they didn't give us reparations, but we are entitled to all the benefits that they have to offer. And so don't be shy, man. Our ancestors sacrificed so we can benefit. So that's the real shot. So yeah, next we're gonna cover charity. Just how this just to show though all the things the state was doing to cheat. You see what I'm saying? All the shit that they was doing to cheat. So charity's next.